Sorry, team. Anybody think I'd never been here before I pressed my button? Yeah. Can you hear me? Everybody? Good. Yeah. No planned fire alarms. So if it does sound, you need to leave by the emergency exits, which are actually if you go through the door, they're that way and that way. We'll take you out. Somebody will show you. But I doubt very much if there'll be a fire this afternoon. Famous last words, I suppose. Yeah. Can I request that all mobile phones are kept on silent and switched off? Thank you. Members of the committee are attending in person here at the Civic Centre, and other members of the council may also be dialling into the meeting via Microsoft Teams to observe and to participate in the meeting. Can't actually see. Is there anybody on? Nobody on. There's no. So at this moment in time, there's nobody else around. Only members of the licensing panel present at the Civic Centre are entitled to vote. Please note that this meeting is being recorded and live streamed on YouTube. Any members on Teams are asked to keep their microphones on mute and only unmute them if they wish to speak. And can I remind members to unmute themselves once they've finished speaking to enable the meeting to proceed smoothly. I'll now ask everybody to introduce themselves, and we'll start with myself again. I am Jane Bell, Councillor Jane Bell, and I'm chairing the meeting.
I'm Councillor Paul Wharton-Hardman. I'm the Vice Chair of the Licensing Committee.
Hello. I'm Hilary Bedford. I'm a councillor for Wotton-le-Dale.
And can I have the applicant's legal representatives, please?
Malcolm Ireland. I am Head of Licensing at Harrison Joyce Solicitors on behalf of the applicant.
And
My name is Tom Havlin. I am the applicant.
Sam Gale, an applicant.
Christian Torgerson, licensing paralegal at Harrison Joyce Solicitors.
thank you. And can we have the objectors, please? Colin.
Fox. Susan Fox, a resident of Lumpton.
I'm Peter Kenworthy and my wife Janet Kenworthy, who are objectors to the situation.
Thank you. And can the officers, please?
Chris Ward, Licensing Manager. I'll be outlining the report. Thank you.
Good afternoon, my name is Tasneem Safdar. I'm the Legal Services Team Leader and I'll be assisting the committee in respect of any legal issues that they may have.
Thanks, Tess. Claire?
And Claire Gornall, Democratic Services Officer. I'll be minuting the hearing.
Right. Now we'll now proceed with the agenda. First of all, it was apologies. I don't think we've got any apologies, have we, Claire?
None, Chair.
Thank you. Declarations of interest. Have we got any declarations of interest? No? Okay. Right. Now then. What I will do is I will tell you how it proceeds for people who've not been before, what happens. And nobody gets shot at the end, I do assure you. Yeah. Right. This is the application for Chapel Lane in Longton. Now, the licensing officer will briefly outline the application, and that is Chris Ward here. And then the applicant will be invited to put forward any information in support of their application, including the calling of witnesses. The objectors and or their representatives, the panel and any other responsible authority may ask questions of the applicant, witnesses and or their representatives. So that's the applicants do it first, right? And then the objectors will be invited to put forward any information in support of their objection, including the calling of witnesses. And then the applicant and or their representatives and the panel may ask questions of the objectors, witnesses and their representatives. So it's they first and then it's you. Okay? It's fairly straightforward. The chair will then ask the applicant if, in light of the representations, they wish to amend their application. The panel will only consider the application laid before it during the decision making. Then there will be a summing up, objector's case, and then the applicant's case, and then there will be a conclusion where the chair will ask the licensing authority legal representative whether there are any other matters to be raised or resolved before the hearing is closed for deliberations. Then there will be deliberations and that generally the public and the applicant will be excluded when the panel is determining the hearing decision. And the notice of decision, the decision will be issued to the applicant and any interested parties 5 working days after the hearing meeting. Right, you're okay with that? That's how it works. Thank you. And I'll now bring in the licensing manager, Chris Ward, to present a report. Thank you, Chris. Got something to say?
Through you, Chair. Sorry, I just wanted to outline in terms of the actual objectors, in what order will they be speaking? So just so that everybody's aware, I have Susan Fox, Peter Kenworthy and Helen Johnson. That's right. Okay, thank you. So if we do it in that order, thank you.
Okay, so to outline the report, the application before you today is for a new premises licence submitted on the 5th of June 2023 by ST Leisure and Entertainment Limited, pursuant to Section 17 of the Licensing Act 2003 for the premises 2 to 4, Chapel Lane, Longton, PR4 5EB. The applicant has applied for the timings of the opening hours for Monday to Friday, 11 in the morning till 11 in the evening, Saturday 11 in the morning till midnight, and Sundays 10:15 till 11 at night. The supply of alcohol for on and off sales, Monday to Friday 11 in the morning till 10:30 p.m, Saturday 11 a.m. to 11:30 p.m, and Sundays 10:15 a.m. to 22:30 p.m. Late night refreshment has also been applied for on Saturdays from 11 p.m. to midnight. As part of the application process, the application has been advertised as required. It's been on the premises for 28 days via a public notice in a local newspaper within 10 days of the application being served, and on the council's website for 28 days. With all new applications, relevant representations can be made in opposition or in support of the application, and can be made by any responsible authority, individual, body or business that has grounds to do so. There's been no representations received from any of the responsible authorities, but there have been 5 representations received from any other parties. The representations mention various factors which raised issues in respect of all 4 licensing objectives: the prevention of crime and disorder, public safety, the prevention of public nuisance, and the protection of children from harm. These representations can be found attached to the report as the appendices. If the licensing authority decides that the representations are relevant, it must hold a hearing to consider them, unless the applicant and all of the persons who've made relevant representations have given notice to the authority that they consider the hearing to be unnecessary. A licensing authority must carry out its functions under the Licensing Act 2003 with a view to promoting the licensing objectives. In carrying out its functions, a licensing authority must have regard to its own statement of policy published under Section 5 and any other guidance issued through the Secretary of State guidance under Section 182 of the Licensing Act. So over to the determination. Members are now requested to consider the evidence provided by all parties, both verbally today and within the agenda pack, and to determine the application in line with the requirements of Section 18 of the Licensing Act 2003, which sets out the steps that can be taken, which are to grant the licence subject to conditions the licensing authority consider to be appropriate for the promotion of the licensing objectives, to exclude from the scope of the licensing activity any licensable activities which the application relates, to refuse to specify a person in the licence as a designated premises supervisor, or to reject the application completely. In addition, today we've received an email from a resident outlining an intent to withdraw an objection from the application. With your permission, Chair, Justin would like to read that intent to withdraw out, if that's okay. Thank you.
Thank you. Yeah, we received an email from Nick Cadwallader, sorry. Yes, he expressed an interest to withdraw, which obviously this is too late to withdraw his objection, but I said I would raise it, that he would like it withdrawn. But in the same token, I did say to him that I can't give any opinion once this has been withdrawn, at which he has not replied. So I would take it as it's not actually been withdrawn as such, because he wanted me to give an opinion of which I couldn't do. Because if it was to be withdrawn, then there would have been no further discussion on the matter. Like I say, I haven't received a reply from him regarding that, but it does say in his email that he has no major concerns, and hence why he wanted to lift his objection. We were concerned about noise, but we have been notified there's a noise limiter in the premises, and he's just put, let me know how it goes. So, all right.
Through you, Chair. So that representation still stands.
Yes.
So
yes.
what I would suggest is that somebody reads that out, whether it's one of the individuals that will be objecting, or we can actually get perhaps the licensing officers to read that out.
Yeah,
But somebody needs to read
can
that.
get the objection. I can read it out if
Thank you.
everyone wishes.
But it still stands.
Sorry. I'm normally loud enough that, yeah, there's no need. So yeah, just after consensus on the position, but my understanding, and you're testing me on the hearing regulations here, I don't think there's any need to read the representation out. The hearing regulations dictate that as written, the representation still gets taken into account. He can't withdraw it. You can only withdraw it, I think it's a minimum of 24 hours starting on the day before the hearing that you can withdraw it. So he can't withdraw it, but the committee can determine what weight to attach to it in light of what you've just been told. So I say, I'm not against it being read out, but my view is you'd have to treat any other representations that weren't here the same. I don't think there's a need to do that. You take it as read as you would proceeding with a hearing with any representation where the party wasn't present.
Sorry, given that it's actually in the pack, I can accept that basically the committee will consider that. Yeah, thank you.
Thanks, Justin. You're being invited to put for your application.
Through me. Apologies. Yeah. Okay. So I'm going to start off just with some background. I always try and start off in licensing proceedings with a bit of background, because I'm always conscious in licensing proceedings that a committee gets to see a set of papers that outline what an applicant's applied for in terms of timings and activities. You don't necessarily get to understand who's behind the application or what the intentions for the premises are. So I'm going to start with that just to give you a bit of context for the proceedings, because I think that can be important. So in terms of who is behind the application, you've seen from the papers, the applicant is ST Leisure and Entertainment Limited. The people behind that company, as you just heard, are Sam and Tom. They're both here, both directors, 50-50 shareholders. In terms of a little bit of background on each of them, so there's more information on Tom in that small bundle that I've submitted. You've all seen that, you've all had sight of that bundle. Excellent. So Sam, there's less information about. So Sam, I understand he's always had a passion for hospitality and hospitality businesses, but he's spent most of his career in his family business, which is a very successful family business, honing his business acumen under the guidance of his parents. And the idea is it's that business acumen that he's bringing to the table. That's what he brings to this business. Tom is probably a bit more important to you, given that he's the proposed designated premises supervisor. He's been working in hospitality since the day he left full-time education. He's what we call in the sector a lifer. I'm not going to bore you with the experience, but I say I will direct you to that CV that I put in the first 2 or 3 pages of our bundle, and I just submit to the committee. We've got some genuine operational experience in the sector there. Okay, the intention is both Sam and Tom will be hands-on within the business. So I say that's the who, and just submitting to the committee. We've got some credible, experienced people that are behind the application. Okay, so that's the who. The what. The what is actually outlined pretty well in the application, because it's a pretty straightforward concept. It's a bar. Okay, it's high end. It will be priced high end. There will be a specialism in world craft beers, but there'll also be sort of quality wines and cocktails. There'll be a food offering, and it'll be targeted at a local ABC1 demographic. I know it can be difficult to sort of visualize a concept on the back of a verbal description, so I've included in that bundle on pages 4 to 10 some extracts from the mood boards, which kind of give you a feel for the premises, and that's what our designers and builders have been working from for our fit out. Have a look at them in your own time. They're nice. All right. My point on it is that we're not talking cheap and tacky. We're not talking grubby carpets, cheap fittings and £2 carling. It's premium. OK, it's a premium product. So that's the who and that's the what. That's the context for the application. I'm not going to dwell on the application itself. I think this is an experienced committee. You've seen new licence applications before, and this one isn't a particularly complex one. I think the only point I would make on the application, I know this seems a bit obvious, but I think given the content of some of the representation, it's nevertheless a point that needs making. In general terms and in relative terms, this is a low risk application. Okay, there's no regulated entertainment. They are relatively early terminal times for licensable activities. Last orders at 10:30 every night other than Saturday, which is 11:30. I say in relative terms, this is low risk. And I mean, we don't believe that granting the application is going to result in some of the problems that seem to be envisaged by some of the representations. It goes without saying that impact is something for the committee to determine, but our view is it's going to be minimal. It's worth noting your responsible authorities agree with that, and I'll come on to why that's important. But I think the point for now, I think when you're looking at the representations, and this can happen quite a lot with licensing proceedings, because there's more narrative in the representations, you focus on that and you lose sight of what's actually being applied for. So I say it's just asking the committee to keep that perspective when they're looking at the representations. So I say no objections from the responsible authorities, but as you have seen and heard, there's 5 from local residents. We did try to engage with the local residents. I always try to explore whether we can amend an application to address concerns from the people that have raised them. You will see in our bundle a copy letter that I sent to each objector on page 11. We've only had actual dialogue with one of the people that objected, and I'll come on to explain that. I will apologise. I think Susan Fox actually got in touch with me yesterday morning via email. I was out of the office, so by the time I got that today, we've tried to converse. We've not conversed. So there's only one of the objectors we've had actual dialogue with. That's Nick, and you just sort of heard that resulted in him trying to withdraw his representation, albeit too late. So that leaves us with all the representations to deal with, and I will deal with those. But unfortunately, this isn't going to be a hearing where I can deal with the representations in the way that I prefer to, or indeed the way that I suspect you would prefer me to. And what I mean by that, the way that I like to deal with licensing here is you look at the issues that are raised and you try and find practical solutions to those issues. That's how licensing works best. I can do that a little bit here, but I'm not going to be able to do that a lot here. And the reason for that is it would be wrong in law to approach it that way, because so many of the issues that are raised aren't relevant for the purposes of these proceedings. So you can't just approach this matter by trying to find solutions for them. So what I'm going to do instead is I'm going to focus on the legal framework, because I think if you look at the application and the representations whilst applying the correct legal framework, it becomes quite clear in my submission what the appropriate decision is. There's 2 parts to the legal framework that I want to cover. I know that the committee will already know this, and I apologise in advance for running through it, but this is one of those matters where if I didn't cover the legal elements, 1, I wouldn't be doing my job, and 2, in the event of an adverse decision, we may have a problem challenging it. So I'm going to ask you to indulge me just for a couple of minutes while I run through those. Okay, so I say two elements of the legal framework to cover. So the first of those is the general approach to licensing decisions. The second of those is what should and shouldn't be taken into account. I'm going to use the case of Daniel Thwaites versus Wirral Borough Magistrates Court to explain the approach. I've put a copy of the judgment from that case in my bundle, pages 12 to 26. I won't bore you with the facts and the history. You may well be aware of that case anyway. I just want to highlight 2 of the fundamental principles that flow from that judgment. So the first of those principles relates to your starting point in matters like this one. I say I'm not going to cite sections at you, but I will ask your legal advisor just to note my reference to paragraph 42 of that judgment. And what that paragraph tells you is that your starting point in matters like this one is a presumption in favour of granting the application. Okay, it's not the case that the starting point is to maintain the status quo. It's a presumption in favour of grant. That presumption can be reversed, obviously, but it can only be reversed where there's objections. I accept we've got those, but also where the objectors can demonstrate that to grant the application is going to result in undermining the licensing objectives. That I submit we don't have. And I know this case gets me cited on occasion. I'm not telling you need, something tangible, evidence or a proverbial smoking gun, but what you do need is more than fear and speculation. And in my submission, we don't have that here. Okay. That's the first principle from the judgment. The second one relates to the importance of the views of your responsible authorities. And again, suspect you know this, so I won't cite paragraphs from the judgment at you, but I just ask your legal advisor again to note my reference, this time to paragraph 55 of the judgment. And what that paragraph tells you is that your responsible authorities, they're your experts in relation to the licensing objectives. So the police are your experts in relation to crime and disorder. The Environmental Health Department are your experts in relation to noise nuisance. Your experts have all received and considered this application, and they haven't objected. And they haven't objected because they don't believe that granting the application will result in undermining the licensing objectives. What the judgment tells you is that as a committee, you should be attaching a significant amount of weight to that. Okay? That's the approach bit. The other bit I'll fly through because I say I'm almost sure the committee will know this, but it's what should and shouldn't be taken into account. It's covered by Hearing Regulation 19, which says a licensing authority must disregard any information given by a party that's not relevant, and by Section 18 of the Act itself, which says that to be relevant, something must relate to the likely effect of the application on the promotion of the licensing objectives. I think on this point, if you look at the content of the representations, the key bit here is that differentiation between planning and licensing. Planning is about the use of the premises, what it's going to be. And I think in this case, so we've been through the planning process. We have a planning permission to be a drinking establishment. That's what we're going to be. Licensing is about how that, once we've got that use, how it's going to be operated. And I think the representation contain a lot of things that point to them not wanting it to be a drinking establishment at all. That means there's a risk of this becoming a rerun of the planning process, and that's something that guidance tells you we should try to avoid. Okay. I need to take you through the representations on that basis. I'm not going to do it by going through each representation line by line. There's some repetition in the representation, so that would just be me repeating myself. I've been through the representations and I've pulled out each individual issue that's identified. I've made a spreadsheet because I'm quite geeky and I like a good spreadsheet. So I've put each of those issues in a spreadsheet. There's literally a theory column. What's the issue? Is it relevant? And if not, why is it not? So I'm going to fly through that. I just make the point on this to be clear. All I'm looking at with these issues is whether or not they're relevant. So just because I say this has been raised and I don't challenge it, doesn't mean I accept it. I'm literally looking at, is it to be considered here or is it not? Okay. So issues raised. First one, I think this is actually raised in, it's certainly most, if not all, the representations, and that's parking. It's traffic and it's parking. Is that relevant? No, it's not. Parking would present the same issue, however the premises is operated, if it's got the use to be a licensed premises. It's about the use, not the operation. That means it's planning, not licensing. That means it's not for here. The next one that you come across is a concern around noise from machinery like air conditioning units, that kind of thing. Is it relevant? No, it's not to do with the carrying on of licensable activities. You'd have exactly the same issue if that was the gym, and you don't need a premises license for the gym. It's not relevant. You've got concerns raised about noise from the emptying of bins. Is that relevant? Yes, it is. We accept that that's relevant. We haven't offered a condition in the application, but we are happy to offer a condition to the effect that there'll be no emptying of the bottle bins externally after 8 o'clock at night or before 10 o'clock in the morning. We say that's a proportionate response to that concern. There are concerns raised about a bar that was run, so it was a pop-up bar that was run in the old post office in the run-up to Christmas that was run on temporary event notices. Is that relevant? No, it's not. The committee will know. Each application gets determined on its own merits. The Grotto, which was what that bar was, it was a different concept. It was operated by different people. So Sam was involved in that, but that was very much it was a very different concept. It was more based on the entertainment. It was a younger clientele. It was a less premium offering. It was a learning curve. And I say Tom, who's probably more important for your purposes because he's the proposed DPS, he wasn't involved in that. You then got sort of three issues that have to be looked at together because they all come from Mr. Cadwallader's representation. So he talks about drug use at the rear of the premises. He talks about fighting or violence at the rear of the premises. And he talks about people blocking access to the properties at the rear. Drug use relevant, yes. Fighting relevant, yes. People blocking access to the properties at the rear, no. I think our position on that. So I said this was the resident that we did have some dialogue with, who subsequently tried to withdraw his objection. His only concern is people going. So if you look at the premises, there's a drive to the left of the premises, and he lives down that drive on the left. His only concern is he doesn't want people going down there. Now we say, look, there's no reason that people would go down there. Everything that we're doing is at the front of the premises. It's front facing. What he wanted was a gate on that drive that we could then say we will close that at 8 o'clock. We're not against that. We've nothing in principle against that, but blame me. I said you cannot offer that as a condition. So one, it's not part of our licensed area. It's not part of our premises. Two, it's not even part of our lease. It's not part of our demise. So it's completely out of our control. So if we say, yes, we'll have a condition on that does that, and then the landlord says, you're not doing it, we're in breach of a condition. If landlord says you can do it and then changes his mind in a year's time, we've got the same problem. We're in breach of a condition and it's no fault of ours. So I say what we can say on that is we're not against that. We've said that we will contribute to the cost of that, but it's not really for us to come up with, and it's certainly not for us to put as a condition on a license. So that's sort of those three, and I sort of throw all those together because it's all about that property down that drive to the left. You then got a concern raised about drink driving. Is that relevant? No, because it's not to do with the operation of the premises. You'd have that issue to the same sort of level, whatever. If it was a drinking establishment, so it's about the use which is planning. You've got concerns raised about rubbish and particularly glasses and bottles. Is that relevant? Yes, it is. But we've offered a condition in the application to the effect that the area outside the premises will be kept clean, tidy, and free from litter. We say that's a proportionate response. You have concerns raised about regulated entertainment. Is that relevant? No. So it is a licensing matter, but we haven't applied for regulated entertainment. You can't object to something that we've not applied for. You've got concerns raised about noise from the use of the external area and a request that a limit is imposed later on the use of the outside area. Is that relevant? Yes, it is. But again, we've already put a condition forward in the application limiting outside drinking to 10 o'clock in that area, which again, we say is a proportionate response to that concern. You've got a concern raised that children will be able to see people consuming alcohol. Is it relevant? I'd say no. I think that's to do with the use. If it's going to be a drinking establishment, I think there's a strong chance that however it's operated, children may see people consuming alcohol. Penultimate one, you have a concern raised that a resident's property will potentially be overlooked. Is it relevant for licensing? No. Again, that's about the use of the premises. If there's a drinking establishment, then that applies however it's operated. So I would suggest that's not relevant. And then lastly, you've got concerns raised that it would be disrespectful to have a bar next door to a funeral home. Again, it's about the use of the premises, not the operation of it. That's it. Okay, that's all of the concerns that are raised across the representations. And I think even though you have sort of 5 representations and it looks on the face of it like you've got a whole lot of things to consider, if you push out the things that aren't relevant, what are you left with? In reality, you have potential noise from the emptying of bins, which we proposed a condition which we say we will address. Drug use and fighting down the drive to the rear of the premises, relevant, but I submit it's based on fear and speculation. And it's that assumption. You can't just assume that granting a premises license automatically results in these things. It doesn't. You can see examples of that right the way across the country. You've got fears about litter, which we've already proposed a condition to deal with. And you've got fears about noise late at night from the external area, which again, we've already proposed a condition to deal with. That's what you've got in front of you. They're the relevant issues. I think to try and sort of tie that in with the legal framework that we talked about earlier, you sort of 5 points to look at. One, the committee is duty bound to disregard anything that's not relevant. That includes planning issues and it includes any issues that's purely about the use of the premises. 2, that means the issues that you need to take into account in this matter are actually very limited. And we would say 3, issues that are relevant, we've either proposed a condition that we say is a proportionate and appropriate response, or those issues are based solely on fears and speculation that we don't think will materialise. 4, and tied to that, it needs to be remembered that in relative terms, this is a low-risk application with relatively early terminal times and no regulated entertainment. And finally, but importantly, that position is one that's supported by your responsible authorities, your experts. So I'm asking the committee, one to sort of bear with me and accept my apologies for running through the legal framework, which I'm sure you already know, but we're asking the committee to apply that correct legal framework, disregard the issues that aren't relevant, and make the only decision which in our submission is the appropriate one, and that's to grant the application. Chair, there are submissions. It goes without saying we're more than happy to answer any questions. Do I need them? No, Chair.
Does anybody else on your side want to say anything whilst
No,
we're
I'm
with
happy
you?
to answer questions if needed, but that's what I'm here for, Chair.
All right. Now then, has anybody got any questions? I will start with you, Councillor. Have you got any questions?
Thank you. Having read the objections, and obviously we'll hear them shortly and listen to yourself, there's a number of, apologies, I'm full of a cold. There's a number of other conditions. I'm just wondering if you've considered with regards to, you mentioned drug use at the back, obviously you're very limited on what you can do. I wonder if there's any provision for condition about no entry or exit from the rear. There's also some objections regarding noise from deliveries. I wonder if there's, again, something you could potentially offer with regards to timing of deliveries. And again, to address any concerns for noise regarding conditions regarding the limiting of windows being open after certain times, doors being open, left open, etc. They're my only questions.
Bear with me. I'm searching for documentation that'll help answer the question. Just bear with me 1 second. Yeah. Okay. So the use of the back, I know I can propose these because this is something that we discussed with Nick, and I've sort of said, look, we can't offer a gate. What we can do is offer to do the things that are in our control. So if we want to sign up saying that the car park at the rear isn't for our customers, that's fine. If we want to sign up saying customers aren't permitted to go down this drive, that's fine. And we're also happy to say that when door supervisors are on, and again, we've not put forward any conditions and don't intend to around this is when they'll be on, but when they are, they will discourage customers from going down there. They're the things that are in our control. We're happy enough to do those because I say we're not against it. Everything is front facing. We're happy to prevent people going down there so far as it's in our power. The noise from deliveries we did actually look at, but don't want to duplicate the planning permission. And there is a condition on the planning permission, which is what I was just looking for, saying no deliveries will be received by the site between the hours of 10 p.m. and 7:30 a.m. Monday to Friday, 9 till 1 on Saturdays, etc. So I think that's covered there. Doors and windows, I would. So personally, again, if you want me to take this away and apologise for being pedantic, it's not something I've got instructions on. I don't like having a conversation here. We'd nip outside for 5 minutes. We come back and discuss. My personal view, and I say, if you want me to take this to the client, we can do. There's no regulated entertainment. So you're talking about people noise only. Any condition that was designed around regulated entertainment before 11 o'clock wouldn't apply anyway because of deregulation. And for that reason, I would normally only put that sort of condition on at 11 o'clock. And that's only going to apply on Saturday nights because we're closed before that every other night. So it's not that it's something that we've not thought about. It's just that it would apply that little and it wouldn't be to regulated entertainment. It's not something we proposed.
Thank you, Chair. I do actually have a comment to make about Nick and Donna's withdrawal of their objection, because I actually spoke to Nick, or both of them, a few days ago, and they said that there was going to be, that they would hope that the problems they discussed would be resolved by a mediation process, and that included the noise abatement measures and having a gate, having a gate put up against their rented property owned by Mr. and Mrs. Kenworthy, and then I suggested that they get this in writing, but nothing has happened so far. And just may I make a second comment? This is, although just to inform me as well that the planning issues are not relevant, to this. The question is worrying over Lancashire County Council's custodianship of the library car park, and because that is not, it was that, yes, I would suggest, thank you. I would suggest that this must be clarified, because Lancashire County Council could enforce a no parking ban on people who are not using the library. But of course, the library is in the custodianship of the county council, not the borough council. So I think there is a difference there. And I've written it down, I've emailed it.
Through you, Chair, sorry to interrupt. But you will have an opportunity to make your comments at a later stage, Miss Fox. Do you have a question to ask?
No, it was only in relation to Nick's, it was this.
In relation
Mediation
to, yeah, in relation to the other objector,
Yes.
obviously he's not here. That objection will be taken into account by the committee.
Yes.
Do you have any questions to ask?
Well, it was this.
Not comments.
No, well, it was the progress of the mediation process. Will that?
Yeah, I accept. I think as explained, so I say blame me because it broke down on this. I want a condition that puts a gate on there. Can I have that in writing? No, because we can't offer that for the reasons that I've explained.
Yes, because it's obviously not their property, so you've got to be very careful about that. Yes, Councillor.
Through you, Chair. Sorry, Councillor Coulton, you're not allowed to speak. You've not made a representation.
Oh.
Because I wrote to ask if I could speak. I did.
Through you, Chair, I've just been informed by the licensing manager that the representation was out of time, and therefore you will not be able to speak, Councillor Coulton, I'm afraid.
We do have protocols and procedures, and if that's it, that's it. I'm sorry, Colin. Do apologise, but rules is rules. Anybody else wanting to ask any questions of the applicant?
Yeah, Peter Kenworthy. I own the property Kirklands at the rear with my wife, which obviously we're concerned about for various reasons. Although I'm sorry, I've forgotten your name. Malcolm Ireland. Well, Mr. Ireland, what you were saying, of course, is very little irrelevant to what we think is. But if I also may say, yes, I've got a question. Is Mr. Cadwallader, who's my tenant, has been told two things. One, which I've answered, was the gates. And I believe two of your, the gentlemen here, I'm not sure who, also said that you would only be opening 4 days a week. And that's why he's withdrawn his objection, as far as I know. Now, can you confirm that or not?
Our position on that is, well, to be honest, it doesn't matter. And I say that on the basis what you've got in front of you is an application for 7 days. So you've got to do, it may well be that we start off, it's a new business. And to be honest, an awful lot of hospitality businesses are doing it at the moment. So it may well be that we start off, but long term, we may well want to open 7 days a week. That's what we're applying the license for. So it's on that basis.
Yeah, 7 days a week is unbelievable. So the owners of the properties around there, it's far too heavy.
Sorry, questions at the start. In a minute, you'll be able to say what you have to say.
All right.
It's only questions at the start. Anybody else with a question from your? Got a question? Nothing. No.
Possibly.
Yeah.
You did mention, Mr. Ireland, that the premises are going to be forward facing, front facing only. But I have a problem that where all the chillers and everything is going to be is about 12 feet away from my open bedroom window. And the noise will just be, I mean, that to you may be an irrelevant issue, but it isn't an irrelevant issue to myself if I am going to be kept awake by that. So, chillers are in constant use and they're constantly clicking on and off. I've worked in hospitality for 40 years. I know this situation. I know the noise they make. And I'm going to have to deal with that on a 24/7 basis. Are you guys going to do anything whatsoever to soundproof or limit the disruption to my life and my peace within my own home that I've lived in for 9 years? And it's been very nice and peaceful up until this moment. And I feel that this is going to be a huge problem for me.
So the short answer is yes. So again, I'm going back to the planning permission because I know that there are things in the planning permission around the soundproofing. So again, I suppose the answer, and again, I take this as it's intended rather than the way that I know it's going to sound when it comes out. it's not that I don't think it's relevant. It's not that I've no sympathy for the position if that's going to cause you issues. It is that it's not relevant for the purposes of these proceedings for licensing, and that's what I'm here to do my job on.
Sorry to trouble you again, but I received an email from an officer saying she noted my desire to speak at this meeting.
You had an email in reply.
Through you, Chair, I'm not aware of any email unless the licensing manager is, but I've just been informed that the representation was made at a time, so hence my comments earlier.
Chair, I might be able to assist with that, Chair. It was myself that Councillor Coulson emailed, which I understood to be as a representing one of the objectors. So I thought perhaps one of the objectors had been in touch with Councillor Coulson, and he'd asked and had been asked to speak on their behalf.
Is that the case, Councillor?
No,
that you're here to speak on behalf of an object,
as a local councillor. That's
no, just no, can't speak. Sorry, Colin, can't. Rules is rules. Sorry, Dad. Sorry, Colin.
Chair, if I may as well just jump in on that. The email was passed to me as well, and the email does say I realise the deadline for complaints about the above ended yesterday, so it was actually came in after the representation period ended.
Is do the proprietors of the proposed business see any conflict with the owner of the actual building in terms of exercising your responsibilities as publicans? Do you see is there any pressure being put on you to or what is that?
So I suppose the answer is twofold. So I suppose it's not, from a licensing point of view, yeah. I'm not sure how it's relevant, but no, I don't think just as far as we're aware, no, there's no conflict between our interest and the landlord's interest. No.
Thank you.
Yeah.
Why, as an objector, were we notified with 53 pages, I believe it was, of your information literally 4 days ago, and then we got another 26 pages yesterday, and that's the first we've known of anything. As the owner of the property immediately behind, that's what I find literally 4 days before. Now, I know it's not relevant to you, but unfortunately on that day, my cat had to be put to sleep and I wasn't there to even read it. So I literally had Friday and Monday, and that's why I didn't speak to you, because I thought this is ridiculous to get 2 days to object to something like, well, 53 pages, the first one, and then the second one was 20 odd pages, which I would think was relevant to yourself.
So I suspect, and again, I'm not sure, but I suspect that when you refer to the 53 pages, we're talking about the public document pack. So, and again, I suspect the other one is the documents that I submitted that I think were sent out either Thursday or Friday last week. So much as I'm, again, take it as it's intended rather than as it sounds, but it's probably a question more for the licensing authority than it is for the licensing committee, and probably not for now.
Yes, but if I may say, it also is relevant to us. At least we could have come back with some question. And of course, it is relevant to us. All these things are relevant, even though you say parking and all the rest of it. It's a nightmare. People backing out onto Chapel Lane. It's really very difficult. Now we can't, I mean, I own half the drive. Yeah. And my tenants can't get in at all because of what's already happening. And that's without.
So I've got to stop you. You can say all this in a minute.
Right. Okay.
Chair, can I just confirm that the report pack were actually distributed 2 weeks ago in line with the regulations that we need to adhere to? Thank you.
I'm thinking most of this was on the public domain anyway.
Yeah.
Yes, so it was available. Yeah, yeah. And you don't have a computer? No, yeah. But there's one of those things, you know, but you did eventually get stuff on hardback, on paper. You got it in paper.
Chair, the objections were received via email, so they was responded to.
And they
via
were
email.
responded to.
Yeah.
So there was some.
So there's nothing on
growing
from our department, no.
Thank you, Chris. Now then, no more questions. So we're now on to your say. So the objectors are now invited to put forward any information in support of your objections, including the calling of witnesses. So this is your chance to put your points to us and to the applicant. These are all the things that are concerning you. All right. So who's going first? Yeah. Is it you first?
Seem to be working that well.
Thank you, Chair. Thank you. So in terms of, I objected in the first instance because I felt it was an unusual person. Sorry. Yes, I objected. Thank you. I objected in the first instance because I felt it was sort of, at the time, inappropriate application next to a funeral director's. So I modified that to a certain extent. So, but my concern is for, you know, privacy of the, I would call them the mourners, if any of them went, you know, in the generic sense, to use the funeral directors. How would that be afforded? And I mentioned as well, yes, again, it's soundproofing, planning conditions, I thought in the planning conditions, soundproofing must be installed by the applicant against the adjoining wall between the funeral directors and the planned new premises. Similarly, on the rear wall of the new premises, as there is an occupied dwelling, which of course is owned by the Donna and Nick, owned by the Kenwares of Donna and Nick are tenants. This is to ensure that both the householders of the occupied dwelling, the funeral director's premises and other local residences in the vicinity are shielded from excessive entertainment noise. I think those are my main objections. Again, licensing hours. I've suggested that the premises would close by 2000 hours from Sunday to Thursday evenings and 2100 hours on Friday and Saturday evenings in circumstances. And there were other, again, these are planning, but it was the ownership of the pavement directly outside the proposed premises. And of course, that to me is, I see it as in the custodianship of Lancashire County Council. It's on the public highway. Yet I had a conversation with Justin yesterday, who said that South Ribble have given a pavement licence in that regard. So there was this conflict between what is actually which is a county council matter, you know, ownership of the public highway and what can happen on the public highway. If it is public highway or if it's privately owned, I think these are important issues. And then I think of other local residents who live nearby, further down Chapel Lane. And then I just this one parking issue, which I know is a planning issue, but it's the use of the library car park, because the librarians were adamant a few months ago, you know, that is only for the use of library, for the use of people using the library. And there's a lot going on in the library. It is a community hub, and Thursday evenings is open till 7. So I think there needs to be clarification from the county council. I've actually emailed to try to get a clear and definitive answer from the county council on this matter, because obviously, you know, it's a decision that they would make. But to my knowledge, you know, the Graham Gooch, the local county councillor, you know, is told me verbally that is the case. But I've written this time to the you know, to the county council who deals with planning, with culture matters, who has, you know, if you like, oversees issues that go on in the library. So it's that issue. But I just hope I've expressed my case clearly. Thank you.
Oh, Mr. Kenworthy. Yes, well, if I may actually mention, Mr. Cadwallader is my tenant, and he, I believe, has withdrawn his objection on the point of the gates, and you'll only be opening from Wednesday to Sunday. Now, that's as I understand it. Sorry? Yeah, well, I'm just saying that why he tried to rescind his objection. Obviously, a lot of things I said originally, seemingly, don't become relevant to because of the planning side of it. But when you own a property down the same driveway, it's extremely worrying, especially when you talk about doors and windows. The doors, I believe, are going to be sliding fully back both ways, so there'll be quite considerable noise coming out. There'll certainly be problems getting in and out of my driveway for our tenants, and eventually when I go and live there, which the idea of having a bungalow is, there are the times of closing on a Saturday and especially on a Sunday, I think are far too extensive. Morning time, not a problem. I think 11 o'clock you open, is it? 10:30 to 11 o'clock. I assume that means that staff will come in at 10:30 for opening at 11. But to be actually closing up to midnight, as you say, for the extension for 7 days a week, I think is crazy, absolutely unbelievable that it could do that. What else? Oh, and of course, all your documentation that has come through in the last 4 days, literally, that's what it's been in the last 4 days. Why has Mr. Havlin, who certainly by what I read on his CV, etc., you've been involved with people before, why didn't you come and speak to us and talk to us about these things? And trying to at least give us some idea of what was going on. We didn't even know it was even happening until, I mean, an A4 sheet of paper in the window was all I saw, only because I've been told. So
it wasn't in the window.
Yeah, there was one in the window. I saw it.
Oh, for the licensing.
Yeah, for the licensing. Yeah, no, the original one wasn't. No, but that's not relevant, of course. So, but noise, yes, I think is a problem, and certainly at that time of night. If you're still going to use the car parking around the back, there will be considerable noise at that time of night. And 7 days a week, I think, is definitely off the cards. It's just far too much. Thank you, officer.
I have a couple of issues that are mainly concerning noise, as I've mentioned previously about the chillers, which are going to be an issue for me. They will keep me awake every night, all night, really. I sleep all year round with my bedroom window open and I'm right next to them. So that is going to be a problem if they isn't structurally addressed in some way. Also, if there is music going to be played, I'm concerned about that, because that I will be able to hear. And if there's sound reducing, but sometimes you can still hear the vibrations through the ground, if it's a very bassy sort of music going on, I don't want to be affected by that in any way. I don't want I don't want to have to be complaining to South Ribble Council every week. That's just a bore. I don't want to be coming round to your house, bar and complaining to you guys. I don't want to do that. I don't want that to be part of my life personally, and I don't want to be kept awake ever. If they're not able to park behind the premises, to the rear of the premises, then all the parking is going to be along School Lane. Again, the large bar. It's a very large bar in a very inappropriate environment. It's in a residential environment. It's not a small bar. It's not just a little micro bar there's a handful of people in. It's a big bar. There's going to be a lot of people. They're all going to be parking along School Lane. They're going to be spilling out at 11:30, 11 o'clock at night. There's going to be noise. So if I'm not woken up by the music or the chillers, I will be woken up by the talking, shouting. People are drunk. They shout, slamming car doors, revving of engines, lights turning on. That will affect me. That will absolutely affect my life. Absolutely. Late into the night. Then there are staff coming and going. They're even later than the patrons. I don't think the size of the bar is appropriate for the site. And it was in the middle of Preston or something with no residential homes nearby, that wouldn't be a problem. You make as much noise as you want, but in tiny little Longton, and with already lots of bars, but they all have their own car parking. Every pub has its own car parking. This has no parking. I don't know, that might be irrelevant, but it's not irrelevant as far as noise is concerned. And that's it, really.
Rules all the time. Yeah. Yeah, but that's not under my jurisdiction because I'm not managing the pub. So I'm just doing this. Yeah. Okay. Right. Fine. Yes. I appreciate that. Yes, Miss Fox.
Sorry. Thank you, Chair. Yes, I had one question. The eating facility, wasn't included in the planning application. I just wondered how it's coming up as part of the licensing.
It's probably one, because in essence it's legal advice, so it's probably one for you rather than one for me. So late night refreshment, which is what we've applied for. Late night refreshment is the provision of hot food or hot drink after. So the reason it's on the application from 11 o'clock onwards is it only becomes licensable at 11 o'clock. It's what brings sort of hot food places into the takeaway regime, but it also applies to hot drink. So if we want to give somebody a coffee at 11:15 at night, that permission needs to be on the premises license. That's why that permission is sought. It's not for, we're not doing takeaway pizza or anything in that sense. That's why that permission is sought.
Several clubs do serve coffee, certainly in the Black Bull in Longton. So you would have a coffee making facility there. And what obviously sale.
Cute. Has that clarified things for you? Good. It's not unusual for that sort of like that to be to carry on. Thank you very much. Done it wrong.
Through you, Chair, it's an opportunity for the applicant and yourselves to ask any questions of the objectors.
Just got a few. Mr. Kenworthy made comment regarding noise outside. The applicant's already suggested a condition with regards to the external area not being used for drinking after 10 o'clock, I believe. Would it be Mr. Kenworthy's wish that was suggested by the applicant that would be slightly earlier to alleviate some of his conditions? The second thing regarding parking at the rear, obviously it's not part of this licensing condition. However, I believe the applicants already suggested earlier on that they would be willing to put signage regarding parking at the rear. So I'm assuming, could that be conditioned potentially? Yeah, and that should hopefully alleviate some concerns. You also made reference to the sliding doors and suggested that they would be left open all the time, which again would potentially cause noise disturbance. Again, I would ask Mr. Kenworthy, would it be your wish to alleviate some of that if the applicant was to put forward a suggestion to have those doors remain closed after a certain time to potentially stop some of that noise? And granted, obviously only from talk, because there's no application for regulated entertainment, but would it be your wish for some conditions to be put forward to support the noise from people talking after a certain time with regards to those doors being closed? They're my questions for you, please. Thank you.
I think as far as, again, going back to the gate, that would be crucial. I would accept if they could put a gate up at 8 o'clock, close that gate at 8 o'clock and stop people going around the back. It would make a big difference. And as far as the doors at the front, yes, again, reduce the timing that they're going to have these till, was it 10 o'clock? You'd be drinking outside. Reduce that timing. I would leave that to the councillors to think about that. And what was the other one? There was 3 things, I think.
You made reference to the sliding door being left open at all hours. Again, I was asking, would it be your wish that the applicant put forward a suggestion with regards to having that door closed after a certain time?
Yeah, those were the concertina doors at the front. That's what it looks like. Are they concertina, may I ask? Yeah, that's what they look like. And there's one big three door that way and 3 that way. So the whole thing is going to be open when the weather's good, obviously. Yes, if it's reduced the hours they can drink outside, that would help. The doors themselves probably wouldn't matter as much, but certainly the drinking outside would be. There was reference to something round the back as well, you mentioned.
Yeah, obviously, the applicant outlined
signage, wasn't it?
Yeah, signage, because that's within the gift. So would that
signage
alleviate some of your concerns?
Yeah. As I say, with signage, that's great, but who takes any notice of it? That's the problem. And if it's dark, they won't even see it, a lot of people, unless there were some lights on it or something. I also would just like to ask one question. Can the people who are drinking, can they walk straight into that driveway if they wanted to, or are you putting something up there? I don't know whether you are or not, where the outside tables are. Very difficult to tell off the plan. It shows a barrier, but it doesn't show anything else. Oh no, this was it, wasn't it? The terrace.
An answer for that one, or
Yeah, sorry.
I know you having a little conflab.
It's
Right.
in all honesty, it's not something we've thought a great deal about. There's no reason in principle that we couldn't do. I think the clients in May are saying we'd be happy to. I think we've got to be a little bit careful about, look, these are the things that we're willing to do and that we can explore and that we're happy to work with you, and the things that we condition. And I'll come on to a couple of points in summing up about some of the condition conversations.
Thank you.
If I may respond to that, the reason why I'm asking is because as we drive out of my driveway, whether it's me, who I was there half a day the other day doing some repairs to the property, I have a gardener comes every week, every 3 weeks, and various people come into service, other services. When you come down the driveway, on the corner of the property here, you can't see it. There's a lot of people there, and say some children run out, we can't see them. And it is a problem there. It is a totally blind, as we're accessing the driveway, we can't see into the front. And if somebody ran out, it could be extremely dangerous.
I can appreciate that, but I think that's well out of our realms of
Oh, well, it may well be.
our power range.
It's just
But
the point I thought
something
I'd
to
ask. Well,
consider, something to consider in our
yeah.
when we're chatting. Thank you. Have you got any questions? No. Sorry. Oh, does anybody want to? Do you want to amend your application at all after being what's said? Sorry. Do you want to amend your application in view of what's been said and discussed?
So there's the conditions that we put forward, which I outlined during my submissions, which I think I said I'd be happy with signage discouraging our customers from going to the rear of the property. That's got to be drafted quite carefully because it's got to putting a sign up is within our control, but the signage also has to say things that are within our control. So I think that'd be something along the lines of signage will be erected in a prominent position on the external wall near to the driveway, discouraging customers from going down the driveway. So no issue in principle with that one. We have suggested the one about bottle bins. Sorry, I'm going back to remember they seem a while ago now. We suggested the condition about bottle bins, which we will be happy not to empty externally after 10 o'clock at night. And I think I said before, was it 8 in the morning? I said, yeah, she's fine. There's 3 other conditions that have been mooted, and I'm just going back to my notes now. So one was around the signage, so that's fine. We've dealt with. I'm trying to remember the other 2.
Sorry, through you, Chair. So one was around the doors being closed.
I've got that one. What was the other one?
And the other one was around the drinking outside at a certain time. I think they wanted to reduce the timing around that.
So the drinking outside, I would be reticent to reduce. And of course, this is in the committee's gift. I'm giving my opinion on the proportionality and the appropriateness of that condition. We've said 10 o'clock. 10 o'clock, in my experience, is not particularly, and so again, the thing that we can't stop, people are going to be going out there to smoke. It will be a nonsense to stop them going out there to smoke, because what you'd be doing is saying, right, you can smoke on the other side of that barrier, but not on this side. It's not regulated. We can't do anything about that. 10 o'clock to me is about the right time, because I say people can go out there anyway. This is the point at which we say you're not allowed to take your drinks outside anymore. You know the theory behind these conditions. They came in when the smoking ban came in. Theory being people will nip outside, have a ciggy, nip back inside if they're not allowed to take the drinks with them. That wasn't just come up with willy-nilly. In my experience from speaking to the clients about the proposed operation, that's what felt about right. And we're not talking about a huge external area either. So that's my views for what they're worth on that condition. That's within the committee's gift. The doors. So I'm always reticent to tell a committee what they can and can't do, or what they'd be pushing it a bit. So my views on the doors. What we are talking about here is noise from people talking, and the committee would have to be extremely careful that they didn't come up with a condition on the doors for a purpose that was regulated entertainment. And my personal view is that the committee will be hard pressed to do that. We've not applied for any regulated entertainment. You've got an A road outside, so you're talking about people noise talking coming out of those doors. So I say it's in the committee's gift. My personal view is the committee should be considering quite carefully from a legal point of view whether they can genuinely direct that at people noise, particularly when you've got a premises that has permission, as we said, from a planning point of view, used to be a drinking establishment, whether from an operational point of view there's a justification in closing those doors early that isn't directed at regulated entertainment. So I say that's the personal view, but it's for the committee to take the appropriate legal advice on that.
Thank you. Now then, objectors, and this is when you can sum up. If there's anything else that you can think of, or you just want to sum up what you've been brought before.
Thank you, Chair. It just that I would stand by the licensing hour reduction that I suggested from 200 hours from Sunday to Thursday evenings, and because Sunday people are going, Monday people need a good night's sleep on Sunday for going to work on Monday. So I think it's better to have early closing on a Sunday. And so I suggested, the premises would close by 200 hours from Sunday to Thursday evenings and 2100 hours on Friday and Saturday evenings. I would also suggest the limited openings that Donna and Nick Wallader were discussing with you. You might find that more financially profitable to open for several days rather than the entire week. Just a suggestion.
Yes, please. Could I ask, you were saying that you'd no jurisdiction over the driveway round to the back. So where are you going to put the bottle bins?
The bottle bins are going to go, we've got a bit of a back corridor, if you will, so bottle bins will live in there, and then we'll bring them out when we're within the hours to
on the school lane side.
Yes, on the other side. So there's a bit of it's almost like a garage around the back, which is connected to us, and that's where our back of house will be. The bottle bins will be situated in there, and then they will be emptied.
So technically, you've no necessity to go around the back onto our driveway and. Right, thank you.
That are those still the issues?
Yeah, through you, Chair, I think there is just one other individual that had an opportunity to sum up. Is it Miss Johnson?
I said already.
Okay, that's fine.
Thank you, Chair. I mean, in essence, I'm saying what I've already said. It's almost a reiteration of the submissions, because what I said in the submissions, there's nothing been brought in that's directly relevant to the licensing objectives since initial submissions and since the original representations. So I'm just going to flick through those 5 points again, which is the committee's duty bound to disregard any issue that's not relevant, which includes planning issues and issues solely around use. That means the issues to take into account here are limited. The issues that are relevant, we believe we've either proposed appropriate and proportionate conditions to deal with them, or they're based on fears and speculations that we don't think will materialise. Tied to that is this sort of urge for the committee to acknowledge and remember that in relative terms, this is a low risk application. And then finally, but of great importance, is that this is a position that's supported by your responsible authorities. That's all, Chair. Thank you.
Through you, Chair, I think there's just one minor point that I wanted to raise it was around the plan. I noticed that the plan makes reference to the premises as 2-8 Chapel Lane. And I note that the application is for 2-4 Chapel Lane. So is it the intention of the applicant to amend that plan?
I don't think so. Subject to you saying differently, I don't think we need to. So we have on that one piece of paper, we have a location plan. The red line there isn't referenced in the key, so that red line serves no purpose. What that red line is, as I understand it, that's all our landlord's title, if you will. So that's what his property is. You then got the bit that's the licensing plan, which is the bit on the left. That doesn't include any sort of reference at all. So it's right, because that location plan is simply, this is the address, this is where it is. The licensed premise is on the left. That's the premises, so to speak. So subject to you saying differently, I don't think there's a need for an amendment to the plan.
Through your chair. So I think we're just relying on the pink shaded plan. Yeah. Okay.
And that's what's referenced in the key.
Yeah,
So
yeah. So in terms of obviously, if there is obviously in terms of the decision notice, we're referring to this pink shaded plan.
Yeah,
Thank you.
fine.
Nothing from me, Chair. Nothing.
Discussion and the applicant and the complainant and everything. So now we go to the deliberations, and I've got to ask everybody to leave because we're going to sit and talk about you at some considerable length, may I add, taking into consideration everything that everybody's said. And we will let you know the decision in 5 days' time. So, but thank you very much, everybody, for coming. I hope you've all had a fair expression of interest, and you've had you say, apart from Councillor Coulton, who will no doubt get me at playtime. But I'm sorry, Colin, the rules are the rules, and it came in late, so there's nothing I can do about that. But thank you for coming. Thank you. And thank you as well. And nice to see you again, Mrs. Wells.
Through you, Chair, just one additional point that I'd like to make is obviously the decision notice will come out to you within 5 working days. If you are, the decision notice will come out within 5 working days. If you're dissatisfied, that's any party here, if they're dissatisfied with that decision, they have a right to appeal to the Magistrates Court within 21 days. Okay, thank you.